Hi everyone, it's Dr. Jensen, and I wanted to give you a little bit more detail about the U.S. Patriot Act and also more information on how it has changed over time. So this will complement your readings that you have for this module as well as prepare you for the final exam. So let's get started. The Patriot Act literally stands for USA Patriot Act, uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. It was enacted due to the terrorist attacks on 9/11 and first signed into law in October of 2001 after a House of Representatives vote of 357 to 66 and a Senate vote of 98 to 1. So it was overwhelmingly passed. Again, due to the context of the time, we had never been attacked this way in the history of our country, and for morale and determination and outcry, we needed to do something. But this was one of the most expansive, broad acts of criminal justice power that we had seen in over a century. So the Patriot Act is literally a law that enhances domestic security against terrorism, expanded surveillance, anti-money laundering oversight, increases border security, removes investigative obstacles, or what we call enhancing coordinating efforts, allowing for administrative subpoenas, or what we call demand letters, rather than a traditional subpoena that has to go through a court and a judge. It aids terrorism victims and families with financial compensation. It increases information sharing between agencies, enhancing terrorism law, including punishment and sentencing guidelines. It improves intelligence gathering. It provides specified training, licensure, and reentry restrictions for certain groups, and grants extended data collection abilities to the FBI and other agencies. Now, there are a lot of other miscellaneous things that the Patriot Act did, so keep that in mind. That's very typical of acts. There are often extra provisions included in there as a way of compromise and conciliation and negotiation between parties. Now, the section you are most likely to have heard of is Section 215, which is officially called the Business Records Provision. It gives the government broad power to ask businesses for their records relating to someone who might be involved in terrorism. So, for example, if the FBI had been tracking Timothy McVeigh in 1995 before the Oklahoma City bombing occurred, it might have learned from business records that he'd rented a truck and bought a truckload of fertilizer, a couple metric tons of it. And so that was kind of some of the logic behind why business records need to be eligible for things like administrative subpoena. So there have been changes to the law over time, and this has occurred in the form of reauthorizations, temporary extensions, provisions that have expired, or what we call sunsetting, and we will go over each of these in detail. So since its passage, several legal challenges have been brought against the act, and federal courts have ruled that a number of provisions are unconstitutional, especially, again, the courts and Congress. So over time, the act has had key parts expire, be revised, and be reauthorized. So the USA Patriot and Terrorism Prevention Reauthorization Act of 2005 represented the first of these reauthorizations. So keep in mind, this is 4 years after 9/11, and the country is still very much feeling the effects of that tragedy. It is also experiencing global effects where we see other attacks happening around the world and in Western Europe that are really making headlines. And so there's still a lot of fear and a lot of questioning about how safe we are. This reauthorization in 2005 created new provisions relating to the death penalty for terrorists. It enhanced security at seaports, and it included measures intended to combat the financing of terrorism, provided new powers for the Secret Service, and a number of other miscellaneous provisions here. So this was the first major reauthorization of this act. Again, more changes over time. There were temporary extensions in 2010 because a lot had happened since 2005 where we start questioning overreach and so forth. But there were one-year extensions that included authorizing court-approved roving wiretaps that permit surveillance on multiple phones, allowing court-approved seizure of records and property in anti-terrorism operations, and permitting surveillance against a so-called lone wolf, a non-U.S. citizen engaged in terrorism who may not be a part of a recognized terrorist group. So we haven't used the lone wolf provision very often, if at all, but it is there and was included in that temporary extension. But we'll go over some more specific things that had happened in the years prior that made these extensions temporary rather than reauthorized. So following a lack of congressional approval, parts of the Patriot Act expired on 2015 in June, and now it's renamed the USA Freedom Act, which has another funny acronym that is part of it, which you can look up if you'd like to. But it did restore and modify several provisions of the original act, but it does contain some new limits on the bulk collection of telecommunication data. So there were some natural sunsetting and expirations that were discussed, but this 2015 act was a more major reform that happened. And these are some of the reasons why. So many members of Congress believed that in the wake of the Edward Snowden disclosures, or his leaked publication of classified National Security Administration NSA memos describing bulk data collection programs of cell phones, they felt like in order to restore that public trust, that would require legislative changes. So we need to rein it in a little bit, because when you have a lack of public trust, then you start getting into other problems with enforcement and the courts and so forth, and you don't want to head toward that road of anarchy and revolution. So this new act was intended to end the bulk collection by intelligence agencies of telecommunications records while preserving the intelligence community's ability to gather information in a more focused way. So in any case, Congress set to demonstrate more due diligence, more oversight, and justification for why this data is needed. Some of the controversies included difficulty balancing national security concerns and civil rights. Many critics worried about potential abuses leading to excessive oversight of our behavior. And so one specific case that we will see a video clip of shortly occurred in the case of Brandon Mayfield, who was wrongfully jailed for 2 weeks on suspicion of involvement in the Madrid train bombings. Later, a judge found that the search which led to his imprisonment was an unreasonable imposition on Mayfield and thus violated the Fourth Amendment. So when we get into violations of civil rights, usually the Fourth Amendment is called into play because it governs searches and seizures, as those of you who have studied criminal justice law understand. Similar challenges on freedom of association, limiting checks and balances, indefinite detentions of immigrants, searching without consent or court orders, roving wiretaps. There have been controversies of surveillance of suspected lone wolves and expanding law enforcement access to records. All of these controversies have created contention about this act. But we're going to see a quick clip of Brandon Mayfield so you can get a sense of what happened in his case.
For over a century, fingerprints have been used to identify criminals, from petty thieves to international terrorists. In 2004, a series of explosions in the subways of Madrid killed or injured nearly 2,000 people. When the dust settled, the Spanish authorities found several partial fingerprints on a bag of detonators.
Now, at the time, the Spanish National Police did not identify anybody to those prints, so they sent the prints to Interpol, who then forwarded them to the FBI.
Melissa Gish is a fingerprint expert at the legendary FBI laboratory in Quantico, Virginia. The FBI's identification led them to a suburb of Portland, Oregon, where a young attorney was working in his office.
I got an unexpected knock on the door. I cracked the door open, and there was two individuals, a man and a woman, and they identified themselves quickly that they were FBI agents.
The FBI examiner determined that this fingerprint found in Madrid matched a print taken from Brandon Mayfield when he was in the military.
They proceeded to push through rather forcefully, to handcuff me. It was just unbelievable. It was surreal. I mean, one minute you're sitting there and you've taken your kids to school and you've said, have a good day and be a learning superstar, and you're working on your case in your office, and the next minute you're heading downtown in cuffs and people are searching you for blasting caps and detonators.
For generations, the FBI and their fingerprint examiners have maintained that fingerprint identification is infallible, routinely testifying that they are 100% certain and there's 0% chance they could be wrong.
Fingerprint examiners have been taught that there's only one person in the world who could have left this fingerprint. There's no scientific basis for that.
Wait a sec. There's no scientific basis for matching like a partial fingerprint?
The premise is that no two people have the same fingerprint. That's the scientific premise. Is that true?
I thought so.
Has there ever been a scientific study to demonstrate that that is true? I don't think so. But even more important, how much alike do they have to be before you say that that fingerprint came from this person? What is the standard for how many points of comparison?
What's the standard, Judge?
It varies from laboratory to laboratory and from witness to witness often. And some will say, we need 16 points. No, 7. And what they all end up saying is that it's really a matter of the individual experience and judgment of the fingerprint examiner.
After Mayfield was identified, the FBI learned he was a Muslim active in his community, which he maintains led to his arrest. Mayfield insisted he was not a terrorist and had never been to Spain. The only evidence against him was that partial fingerprint. But at the FBI laboratory in Quantico, the print was matched by a second examiner and then confirmed by the head of the FBI's fingerprint unit. So 3 examiners would say that this was Brandon Mayfield's fingerprint.
In this case, they did, yes.
And I believe they provided an affidavit saying it was 100%.
That is how they did testify in that manner, yes.
A Portland, Oregon man has been arrested by FBI.
Officials are detaining Mayfield in the county jail
His
here.
fingerprint was found on a plastic bag with bomb-related material.
He can be held indefinitely.
It was a nightmare. You know, when you're there in your jail cell alone and you're just faced with your own thoughts, that's when the gravity of the situation really sunk in.
Okay, so you're in the lockup. They say that you're 100% matched. Your lawyers get a fingerprint examiner, right?
Yes. The one hope was that this fingerprint examiner would straighten it all out and wouldn't agree with these other 3 examiners who had said that this is a 100% conclusive match.
I received a call from Portland, a request which I get many times a week to take a look at a print.
Ken Moses was selected as the independent expert in the Mayfield case.
I didn't know what finger they'd identified, so I had 10 possibilities. So I started with the thumb, went to the index, went to the middle, no, boom, I come up with one, here's one with a couple of similarities, a couple more, and by the time I got to 15, I said, this looks like an identification.
So then you got on the phone with the court.
That's right.
And you testified. And what did you tell them on the phone?
I say I've examined the known print and I've concluded that the fingerprint is a positive match. That's what I told them.
He actually confirmed what the other 3 examiners had said. And from that point on, I kind of felt like the train to a death penalty had just pulled out of the station.
Mayfield says his own lawyers assumed that the print was his. 2 weeks into his detention, he had to decide whether he would testify or exercise his right to remain silent.
I was going to go to the hearing and tell the judge what it was I was going to do. I was either going to testify or not talk. And you have to excuse me because it was difficult. I waited and I waited, and my attorney showed up. He said, "Brandon," he said, we just learned it ourselves that the Spanish police had identified this latent fingerprint as belonging to an Algerian." And I looked at him and I said, see, I told you. I told you it wasn't me.
When you heard that it wasn't him, what'd you think?
Well, I knew that our profession had taken some sort of a quantum leap because suddenly there were new rules involved. No time before in history had there ever been two fingerprints with 15 minutiae that were not the same person. Under our past standards, I was right, but I was wrong. I had made an error. And so had every other examiner that looked at the print. So therefore, when I heard that it was an error, I knew the ground had shifted somewhere, and indeed it had.
We've been using this for 100 years. We ought to have some serious amounts of science to support the claims that examiners make.
So it hasn't gone through. Jennifer Mnookin, a law professor at UCLA, is heading a study funded by the Justice Department on fingerprint identification.
What matters here isn't, are your fingerprints really different from that guy over theirs? The real question is some part of your fingerprint sufficiently similar to some part of his that a competent examiner might mistake some part of your print for a part of somebody else's print? Well, that's exactly what happened with Brandon Mayfield.
All right, so that gave you a little bit of exposure to the Brandon Mayfield case, and you can see that there certainly were other elements going on with the fingerprint examination and so forth, but even getting access to those things really represented an overstep on the Fourth Amendment. So these are things we have to keep in mind as we have well-intentioned ideas to protect ourselves and use all the available tools at our disposal for law enforcement to successfully bring to justice people that try to harm or hurt us, but at the same time making sure we get it right. And we don't forfeit some of our civil liberties, which also are why we enjoy life in our country. So with these two challenges at play, this class is not meant to put forward a policy recommendation or decide on how best to do that. We leave that in the hands of our elected officials. But it at least brings to bear some of the challenge that comes here. And really, I leave my students to determine on their own where they see themselves on the juxtaposition between security and privacy. But hopefully this brought more ideas to light when we talk about something as serious as a train bombing and as serious as a wrongful conviction or a wrongful imprisonment. So we need to get it right on both sides. And I don't know exactly how to do that, but at the same time, I think it's important to examine what's in front of us and determine next steps. So hopefully you enjoyed this little overview of the Patriot Act and going a little bit deeper into some of the controversies of it, the changes of the law over time, and really what it's about. And I invite you to continue to look at it as you study. And I wish you very best of luck on your final exam. Thanks.